Perfect. We're a go.
Well, good morning, everyone. Thank you so much for joining the second webinar in the Mining and Consent Expert Roundtable Indigenous Legal Frameworks sessions hosted by the First Nations Energy and Mining Council. I am Valérie Courtois and I will be your moderator today. I am calling and joining in from the land of the Innu called Nitassinan, more recently known as Goose Bay, Labrador, and it's a great honor to be here with you this morning. In order to start our meeting in a good way, I'd like to now turn to Elder Larry Grant from the unceded Musqueam territory and nations. I believe your traditional name is Slieslios? Slieslos? You can correct me, please, Mr. Elder Grant. So over to you to start us in a good way.
Thank you. Good morning, everyone that's logged on here today. FNEMC to the Homo, Kushwi to Kushai Art, to now whale. Flock says Johannes Capelano, Hotimilto, Kus Helixtuk, the Huinar, Emignetten, Kushwi to this all Tamakus was well. The Equinus Johannes Capelano sets something need to swallow a helix dollar to swallow up a nomet to now whale. You want to know I tennis qualifying because a song the helix dollar. The Equinus Johannes because Amistum Sassan the I see much see him qualifying because because no need high tap calcium to the CIA CSM high tap calcium CSM. I want to say good morning again to everyone that's here, and it's very, very good and my privilege to be honoring you. All of you that are logged on this morning. I'm coming from the traditional unceded lands of the Hunkaminam speaking Musqueam people, now surrounded in Metro Vancouver, which was our primary resource area prior to Confederation, and being corralled and confined to less than 200 hectares of land, which is very, very unnerving to our people. And I would just like to say, I really, truly am happy that we are having these discussions that should lead to relationships with the First Nations and very, very much needed dialogue between the industrial people and the First Nations that have desecrated the majority of our lands without any compensation to the First Nations peoples, and toxifying the lands without remedial programs to bring them back to where they are livable to our First Nations people. So I want to say thank you again for all of you that are attending today. And hopefully we have a very fruitful discussion together. Colette Quincy-Ziatala, Tiswallop, Hui Nam, Hui Ti, Tisansam, Queen. Thank you very much, Jim.
Thank you so much, Elder Grant, for that beautiful opening. At this time, I'd like to turn it to the chairperson and CEO of the First Nations Energy Mining Council, Mr. Dave Porter, for a few opening comments.
Good morning, and
Thank you very much, Val. I'd like to begin by thanking our friend, elder, and cultural advisor, Larry Grant, for his welcoming remarks. And as indicated, this is the second of the Mining and Consent Expert Roundtable discussions. Last week on November 26th, we had the international panel. So we had learned scholars such as Chief Willie Littlechild, Daley Sambo-Doro, Megan Davis, and they did a tremendous job in discussing not only the UN Declaration, but associated international documents and protocols that link in to the UN Declaration. And with respect to today's panel, we are going to have, again, an exemplary lineup of some of the leading thinkers about not only the law, but the application of the UN Declaration, and specifically free, prior, informed consent as it relates to our people and their relationship with public governments. I would be remiss to not speak about the federal process. We received, at least I was made aware yesterday, that the federal government is intending to bring into Parliament legislation, federal legislation, with regard to the recognition of the UN Declaration and its implementation. So I will ask lawyers for our organization, specifically Stacy Fox-Adzurza, who's on with us, and Merle Alexander, that if they could turn their minds to do an analysis of the incoming federal legislation, and that we would then undertake to share that analysis with you in the third webinar, which will take place on December the 7th.
The 10th.
The 10th.
Mm-hmm.
Okay, I've been corrected. Valerie, you're hosting an interesting webinar on December the 7th, including Mr. Paul Martin and Mr. Bob Ray. So there's so many of these things going on that, pardon my confusion. And so I look forward to participating on that webinar, Valerie, and I'm sure that you'll let people know about that particular webinar today and invite folks that are interested in participating there. And so we've designed this so that there will be 6 webinars in total. The first 3 will be designed to impart information to our leadership. And we've been assisted not only with the expert panels that have come together, but we have some of our legal counsel, such as Stacy Fox-Adzurza and Merle Alexander, that will then participate in a panel discussion. And then when we conclude these first information-focused panels, we will do 3 additional panels in March, February. And those panels will have a different design. Once we conclude the initial 3, we will develop a discussion paper. We will then, and that discussion paper, of course, will be focused on the information that we receive in the first 3 panels. And that discussion paper will be circulated to our leadership. And we will then have the 3 additional panels, which will be designed to be interactive and have our leaders be able to make comment share their ideas, thoughts, analysis, and to be able to, at the end of the day, contribute to what will ultimately be a published report of all of the events that are occurring. And that report will be assisted through the help of the BC Law Foundation, which is one of the partners with us on these webinars. Before we begin the panel discussions, I'd like to take the time to quote a relevant section of the UN Declaration that describes the work that is before us. And I refer to Article 32, Sub 1, affirming that Indigenous peoples have the right to determine and develop strategies for the development or use of their lands, territories, and other resources. In accordance with Article 32, Sub 2, states must consult and cooperate with Indigenous peoples in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. Now, we are living in a very uncertain time with the pandemic influencing and affecting all of our lives. And it's very difficult for our communities to put focus and effort and resources to a lot of the political, legal questions because I'm getting some feedback, but I'll just continue until somebody stops me. In the midst of this pandemic, the BC government has determined that mining to be an essential service. So while our leadership is preoccupied with significant community issues, infrastructure, we heard the other day that the federal government has not made good on its commitment to eliminate boil water advisories in our communities. As an example, many of our communities live in the boreal forest, which contains some of the world's fresh water, 1/3 of the fresh water on Earth. Yet we still are in a situation where community members aren't getting clean water. That's one example of many pressures that our leadership have to deal with. But I think it's very important that we continue to keep our eye on the UN Declaration. Climate change affects everyone. It is an issue that we are also dealing with. So as we go forward, I believe that we should do all of this work within the lens of climate change and the UN Declaration. And so that's my perspective. And we're going to hear from individuals who are working in many cases on a daily basis to ensure that the rights of our people are protected and that we work together to find solutions as to how can we effectively implement the UN Declaration here in BC with regard to legislation that was passed over a year ago, and as well, how can we work with our federal government to ensure that our views are incorporated in the process of not only recognition of the UN Declaration, but more importantly, as to how we implement the Declaration going forward. I would now like to turn to introducing our moderator for this event. Valerie is a registered professional forester who specializes in Indigenous issues, forest ecology, and ecosystem-based management and planning. She is a member of the Innu community of Mastui, located on the shore of Lac Saint-Jean. Valerie holds a degree in forestry science from the University of Moncton. She has served as a forestry advisor for the Assembly of First Nations of Quebec and Labrador, forestry planner for the Innu Nation, and as a consultant in Aboriginal forestry, including certification in spatial planning and caribou planning. In 2007, she was awarded the James M. Kitts Award from the Canadian Institute of Forestry for her early career contributions to the forestry profession. Valerie has been the director of the Indigenous Leadership Initiative since 2013, and I'm privileged to assist her in the work with ILI. There she has led a team, she leads a team of dedicated Indigenous leaders from multiple nations in Canada on decolonizing conservation, ensuring the fulfillment of Indigenous responsibilities to the land, and promoting the role and importance of Indigenous guardians. She has received numerous awards for this work, including being recognized as a Labradorian of Distinction in 2017. In addition to her work in conservation and planning, Valerie is an avid photographer, and I've seen some of her photos. They're a beautiful one. I like the one with the tent and the light in it, the northern lights behind. That's one of my favorite photographs. She's also on the board of directors of the corporation, one of her Nations Corporation, a nonprofit that encourages cultural and professional exchanges on the George River. She lives in Happy Valley, Goose Bay, Labrador. I'd like to now turn the management of this process over to my good friend, Valerie.
Thank you so much for that warm introduction, Dave, and for that opening for our attendees. Before we dive into the subject of the matter, I've got a few housekeeping notes. First, the webinar will run for 3 hours from 9 a.m. Pacific time to 12 p.m. Pacific time. The webinar will be chaired by Dave Porter, CEO of the First Nations Energy and Mining Council. There will be four expert panelists who will present the summaries of the concepts from the expert papers they have all written. And the 4 panelists will be Mr. Doug White, Ms. Cheryl Lightfoot, Mr. Roshan Dinesh, and Mr. Paul Joff. After the 4 presentations, there will be a discussion period. Member of the First Nations Leadership Council will be asking the panelists some key questions. Each panelist will be giving an opportunity to respond. The question and answer application has been turned off to all attendees, as there will be community engagement webinars held in February and March, where you will be given the option to ask questions directly. If you have a question, please send it to Jim Dory after the presentation, and he will forward it to the appropriate people to answer. We also, I just want to highlight as well, a survey that has been put in place relating to impact assessment. And so Dave Porter, CEO of the BC First Nations Energy and Mining Council, has requested a survey be made available to First Nations interested in providing input on impact assessments. The First Nations Energy and Mining Council is collaborating with the Impact Assessment Agency to better understand the wishes of Indigenous communities with respect to dispute resolution in impact assessments under the new Impact Assessment Act. The goal is to identify ways to support nations when these federal processes occur. As you know, the federal and provincial governments have passed new environmental assessment laws last year. Of interest to FNEMC is to understand what types of dispute resolution mechanisms are of interest to First Nations. A report will be developed and posted on the First Nations Energy and Mining Council website in the second quarter of 2021 for First Nations. The survey will be opened at the end of the 3rd webinar on December 10th, and will then draw, there will be an Apple iPhone draw on December 11th, and the link is available on the First Nations Energy and Mining Council website at www.fnemc.ca. I believe Jim is also going to post a link to the survey in the chat for you all. At this time, I'd like to introduce Mr. Doug White. Is he online? Yes, he is. Mr. Doug White is the director of the Center for Pre-Confederation Treaties and Reconciliation at Vancouver Island University and practices as a lawyer and negotiator across the country for First Nation governments. He was elected chief of the Snuneymuxw First Nation, and I'm really sorry for the pronunciation for this Innu speaker. Your West Coast names are hard for me to pronounce, but I give it a go. From December 2009 to February 2014, where a major focus of his work was in relations to the implementation of the Snuneymuxw Treaty of 1854. Excuse me. From June 2010 to June 2013, he was elected by the chiefs in British Columbia to lead the First Nations Summit as a member of the First Nations Summit Task Group. He was also a member of the BC First Nations Leadership Council, working on common issues with BC First Nations. Over to you, Mr. White.
Thank you so much, Val. Asiam na siaya. Enta pekulasultan tanis na nemo. Ait na squala wanquanas I haitzepka siam estimo. Really thank my Uncle Larry Grant for his opening words. And thank Dave for the invitation to be a part of this work. And thank you, Val, very much for the introduction. This is an issue that I think is really essential to our time. We're in a very dynamic moment in the relationship between Indigenous peoples and the Crown. And one of the largest outstanding issues that has not been settled domestically in any significant way is the issue of self-determination and self-government. This is an issue that is rooted, of course, in the Indigenous sovereignty of our peoples. That is a simple fact of history, that we are sovereign peoples, and that when the Crown arrived and issued the proclamations of their own sovereignty and took various kinds of steps, it may have in some way diminished or displaced the sovereignty, but it did not extinguish that sovereignty. And so when we've got, this is a key element that we need to work through and talk about amongst ourselves and with the Crown, is this idea of firmly reframing the discussion around the reconciliation of sovereignties. The rights framework under Section 35 has been articulated in a way and at a time period when we all know that it was not really permissible. It was not really, there was no way to talk, Canada did not have the tools to talk about Indigenous sovereignty in the courts in the 1980s and the 1990s. And so in major important decisions like the Sparrow decision that began to, that really laid the foundation for what Section 35 rights are in the Canadian constitutional context and in the Canadian constitutional framework, something unusual happened and remarkable, and I think something that requires a significant course correction. Rights were framed in the context and in the language of culture, that what was primary and what was essential was not that what Section 35 wasn't conceived through the court litigation process as a space to resolve and reconcile the tension between the pre-existing sovereignty of Indigenous peoples and the asserted sovereignty of the Crown, and that with respect to Indigenous sovereignty, the obvious dimensions of the inherent self-determination and self-government, and the very special and important relationship with territory known as Aboriginal title, that it wasn't that seeking to be brought into some kind of alignment or relationship with assertions of the Crown. It was simply the idea that somehow let's frame Section 35 rights around the idea that they should be somehow the activities that are protected that are integral to the distinctive culture of Indigenous peoples. And so I do think we have to understand that basic point when we're thinking about now a very pronounced shift out of these patterns of denial and out of this pattern of inability to address the reality that's in front of us of self-determination and Aboriginal title, that we have to understand culture in the context of Section 35 as something of a proxy for the sovereignty of Indigenous peoples. And so when we see the jurisprudence in that light, we can see how there's been significant distortions, and there's it's a path that is fundamentally, in some ways, wrong-headed. And so now we're now in a time period when the Crown is saying that we're going to shift into out of patterns of denial into recognition. We're going to embrace the United Nations Declaration. We've been through major processes like TRC, the Truth and Reconciliation Commission process, and earlier the Royal Commission. And the TRC very importantly said and pointed to Canada to embrace the United Nations Declaration as a framework for reconciliation for Canada. They did that. I think it's a very, very important thing for us as Canada, because here in Canada, what we lack is any domestic tradition of recognition. There are no patterns that exist in the relationship between Indigenous peoples and the Crown that are premised on the idea that Indigenous peoples have a say. And so when that's so, when every pattern of behavior, every policy, every law, every form of interaction is all premised on the idea that there's only one decision maker in this country, and that's the Crown, then we're in a very difficult place when we think of what the status quo is as compared to where we need to go together. And so for lack of any kind of domestic tradition and patterns to build upon, the importance of the UN Declaration as a comprehensive framework of reconciliation could never be more important. And so very happy to hear that the federal government today has put forward the legislation. Hopefully it is a solid foundation to build upon and work from. But what I'm going to talk about in this brief talk, I understand we have a few minutes, is the Energy and Mining Council posed a few questions about self-determination and consent. They asked, who is to decide how a nation self-governs? And what are approaches to dealing with internal governance issues that may need to be addressed in the process of determining consent? And what approaches may address the roles of both hereditary and traditional leadership and band councils in a consent process? And how might these approaches be employed in the context of the Declaration on the Rights of Indigenous Peoples Act, the Provincial Act, which recognizes, in quotes, Indigenous governing bodies? So in answering some of these questions, it is important to have some of this basic background information about the history of the development of this area. And I should comment, where I'm from in Snuneymuxw, the Snuneymuxw First Nation was the last nation to sign a treaty in the pre-Confederation era with the colonial government of James Douglas. That was in December 23rd of 1854. And I remember I was chairing a session for, I believe, the BCFN up north sometime in the last couple of years, and there was one of the executive from the BC Mining Council was up there talking, and he said something along the lines of, we are about to go somewhere where we have never been. And that was about, with respect to the mining industry, recognition of the need to have the right relationship with Indigenous peoples prior to mining and just all of the stuff that we're talking about, consent, et cetera. And so I said to him, I said in my comments after he was done talking, I said, it's important to know that this isn't new for British Columbia. In fact, this is where we began. There's 14 treaties on Vancouver Island from 1850 to 54. 3 of the treaties, the 2 up in Port Hardy with the Kwakwaka'wakw speaking peoples up there, and the final one with the Snuneymuxw people in 1854, those 3 treaties they all came about because the Crown believed and realized that there were coal resources, there were mining resources that the Crown wanted to access. And they knew that they could not access that resource without first having the proper relationship with the Indigenous peoples. And so the pattern was there in the beginning. Of course, everyone knows that December 23rd, 1854, the treaty was signed. Well, that was the last one, and for whatever reasons, the Crown went off in a different direction and began the pattern of denial. But really, when we're talking about in the context of mining, talking about things like consent, this really is, it's important to know that historically, at least, this is a return to a pattern that was originally established so long ago in the colonial government context of Vancouver Island in the 1850s. So self-determination, self-government, another important broad point to make is that while going back about half a century now, as the Indigenous peoples began to use the courts, we began the process of developing an enormous body of law, new law in Canada about Aboriginal peoples that covers all kinds of major issues, from treaty rights to Aboriginal title and Aboriginal rights and a broad spectrum. But there is a very large omission. There's a huge smoking hole in the middle of all of this body of law, and that is about self-government. And so it's an issue that just simply has not been addressed in a major way. There have been lower level court cases, like the Williams decision, and in Justice Williams in the Campbell decision. There are, the Pamajawan in the Supreme Court of Canada, kind of like an unusual sort of fact pattern that the court never really grappled with in a fulsome way. The courts have never really fully addressed the issue of self-determination and self-government. And so in that regard, there's not a lot of guidance from half a century of litigation on this issue. It's there in the margins because of the distorted way that Section 35 jurisprudence is set up. It's kind of there, always lurking in the background. We saw that in Chilcotin Nation. We see the inevitable conclusion that Indigenous peoples have a governmental relationship with territory that includes decision-making power. And so now the work and the task is to illuminate for the world what every Indigenous people, the way that we approach self-determination, self-government, decision-making, and to build that up as much as we can inside of our own nation. So the very first question, who is to decide how a nation self-governs? The only answer to that question can be the Indigenous people themselves. And it's a little bit related to the way that Justice Vickers talked about the Chilcotin Nation, about who holds Aboriginal title, who are the proper title and rights holders. We've had this history in Canada, of course, of enormous colonial apparatus and mechanisms and policies and laws established and erected to interfere with who we are as Indigenous peoples in the way that we governed ourselves. And that includes an enormous range of activities that took place, that included establishing band councils and prohibiting the potlatch. In BC was a major step under the Indian Act. The discrimination against women and interference with matrilineal systems and matriarchal systems, removing our children and sending them to residential schools and establishing Indian reserves. That was all done through the Indian Act. And so there was a really significant displacement and disruption of traditional systems of governance. And where the Crown went through and decided that, okay, you people over here, you're an Indian band, and you're an Indian band, and you're an Indian band. And I think that, perhaps sometimes that lined up with the Indigenous peoples, but quite often it didn't. It separated peoples from each other. And so that's the, you know, the wreckage that we have from all of the history of colonialism is a significant reality for us to grapple with. And so when we think about who is it that determines how we self-govern, it can only be the people themselves that are the proper title and rights holder. And the way that was described in Chilcotin Nation was that it is the historic community of people sharing language, customs, traditions, historical experience, territory, and resources at the time of first contact and at sovereignty assertion. And so, in other words, the collective that holds title and rights is determined and shaped by the historic and lived reality of Indigenous peoples. For these reasons, who is the proper title and rights holders will vary. In some instances, it may be a large collective, and others a smaller. And determining this requires a real understanding of both the common law tradition and Indigenous laws, experience, and knowledge. So this is going to require Indigenous peoples to have to work through and talk about those basic elements to determine for themselves who they are as a people and what the proper title and rights holder is in their context. The second question I want to answer for you is what are the approaches to dealing with the internal governance issues that may need to be addressed in the process of determining consent? This one also is of course an internal matter, a purely internal matter to the Indigenous peoples that the Crown and industry have no real role in. And the necessary implication of this is that the forms of these governments will be diverse and distinct. They may encompass multiple forms of elected and hereditary systems. And that's the work of the nation and the government rebuilding that must be led and determined by Indigenous peoples themselves, utilizing their own laws and internal processes. And so that internal work of going through and articulating laws that are rooted in the self-determination and express self-government, important, I mean, I think that one of the key points to make here is that the fundamental real work of our people in our advocacy for over a century has not been aimed at achieving consent. That consent has not been the goal, although that is an obvious byproduct of it. What our goal has been about to be self-determining. And when we are self-determining, we then, when there's more than one decision maker, what becomes necessary is a consent-based framework of decision making. And so if you want, the point I guess is that if you want to be in a powerful position of consent, you have to be in a powerful position of self-determination. And if we look at the trajectory, this has been a very important development over the past almost however many years it's been now, since 2004 in Haida Nation. The Supreme Court of Canada made a very important decision that prior to that decision, the view of the Crown was simply the Crown can do absolutely whatever it wants. It is unconstrained by any consideration of any potential Aboriginal right or title. Any rights that have not been proven are irrelevant to Crown decision making. Of course, the courts in 2004 in Haida Nation disagreed with that and said that the honor of the Crown requires a duty to consult and accommodate. And that fundamentally changed relations with us in a pretty significant way. Instead of being entirely excluded, we're now in the room. But it's important to keep in mind, of course, that the framework of Haida Nation is firmly rooted in the idea that there is only one decision maker, and that is the Crown. And that as the Crown, part of the Crown's decision-making process, it has to engage with Indigenous people and consult and whatnot. But ultimately, it's the Crown's decision to make. Now, so that's the consultation framework. Then we get to 2014, a decade later, in Chilcotin Nation, and the court talks about the implication on decision-making of the reality of Aboriginal title, and Aboriginal title that is territorial in scope, that is across large spots and large areas. And what they said was, you know, while it was a little bit obiter on this point, the court talked extensively about what are the implications of the kind of Aboriginal title that the court is confirming in terms of the theory of Aboriginal title being territorial in scope, and that it's existed since 1846 and that it's there today as we speak across British Columbia. They said the implication is that we need to shift now into a pattern of consent-based decision-making. So in terms of, you know, this is determining consent and building up the self-determination framework and infrastructure that's required for self-determination. When we do that in the right way, then we get to the most powerful form of consent we can. Another question, what approaches may address the roles of both hereditary and traditional leadership in band councils in a consent process? This also is very important internal work to be done by Indigenous peoples. And it also will play out in many different ways. There's no one unified sort of form of hereditary leadership or traditional customary leadership and leadership selection processes. To my knowledge, there's very many different forms of that that exist. I think that we need to be very careful that we don't undermine the efficacy of our existing governments as they are. We need to keep in mind that the governments, while they may have been elected under the Indian Act in many circumstances, they have been elected by the Indigenous people themselves. And so there is that measure of authority. There are places like where I'm from in FNEMC where we have established our own leadership selection process under our own customary law. And so while we're working through this transitionary period, it's going to be messy, but we need to have our eyes clearly on the end goal of where we need to get to, and to make sure that we're doing everything we can to strengthen our governance systems and to build a clear and powerful path, transitionary path to future forms of government. And finally, the Indigenous, how might these approaches be employed in the context of the Declaration on the Rights of Indigenous Peoples Act, which recognizes Indigenous governing bodies? This one, this question, I just got to find my notes here on this. The first,
jump in here and just let you know you're on times. You're at time, so
yeah, I've got about 1 minute, and then I'll be wrapped up, Val.
great.
Thanks. So the framework of in the legislation, Indigenous governing bodies defined as an entity that is authorized to act on behalf of Indigenous peoples that hold rights recognized and affirmed by Section 35 of the Constitution Act 1982. The first half of the definition reflects the principle of self-determination, that it is an internal process of authorization by an Indigenous people. And the second half of the definition reflects the principle of the proper title and rights holder. In this way, the definition properly distinguishes between the two questions and the different legal principles that must be applied to answering each one. And so I think that I will leave it at that for now. Appreciate very much the opportunity to put forward a few thoughts for this important discussion and to be a part of this panel. So thank you everyone very much for the time and the opportunity and for your attention. Hai tsep kasiyam.
Thank you very much, Mr. White. I'd like to now turn to our second expert, Dr. Rashan Dinesh. Rashan is a lawyer and a conflict resolution innovator, an educator whose area of work, teaching and writing include conflict resolution, peace building, constitutional law, Indigenous rights, inter-ethnic and inter-religious dialogue, policy development and implementation and organizational dynamics and cohesion. Rashan completed his doctoral studies at Harvard Law School and has taught at many academic institutions around the world, including University of British Columbia in Vancouver, the European Peace University in Austria, the Justice Institute of British Columbia in Vancouver, University of Victoria, and the Landleg International University in Switzerland. For the past decade, Rashan has also worked extensively with First Nation governments in Canada on the advancement and protection of constitutional rights, design and implementation of negotiation and reconciliation processes, and governance and strategic development and dispute resolution. With that, I'll turn it to you, Dr. Dinesh. Thank you.
Great, thanks, Val. Thanks to the Elder for the wonderful opening this morning, and to the organizers. I'm coming to you from the territory of the Lekwungen speaking peoples, the Esquimalt and Songhees First Nations. Very honored that they allow me to make my own home here and join you from here, from their territory today. And just want to express how honored I am to be with all the fellow presenters. I'll just going to speak very briefly. The question that I had written a paper on was really about property rights, ultimately, and the question was about the granting of consent and how consent would operate in the context of Aboriginal title and the reality that Aboriginal title has not been declared or recognized formally over much of BC. And, you know, ultimately, I'm not going to go through the doctrine recounted in the paper, but there's a bit of a red herring in the question, in that it doesn't make any difference whether Aboriginal title's been declared by a court or recognized by a government. It exists where it exists. And I may touch on that in a bit, but if you throw up the slides, Jim, I have two images that I wanted to share, because I actually thought it would just be useful to zoom out at a 10,000 foot lens a little bit and just talk about the moment in time that we're in. That's not my image. Oh, there's my image. And I think Jim might share these in the chat box so people can download them if they wish to. You know, I've just been reflecting about, and of course people are talking about legislation, and I might have a few remarks on that regarding UNDRIP, but just about the moment in time that we're in this work. And what this diagram shows is the tension that's really existed for decades now between governments in quite a bit of a rag the puck, adversarial, highly incremental, slow-moving dynamic, grounded in denial-based approaches, and moments in time where Indigenous peoples, through their advocacy and leadership, brought about a context where it was felt that transformative change, the new foundations that were needed to address the legacy of colonialism, would be brought into place. The yellow dots are these transformative efforts and moments, and the lines at the bottom show this slow incremental plodding along as governments dug in their heels and failed to make and shift the roots and foundations of what needs to be done. So this tension between incremental and transformative and foundational shifts has been with us for decades and decades. Of course, many thought Section 35 might be that moment, and of course, you know, governments treated it as an empty box and forced things into the courts, and public service adopted, you know, negotiate forever approaches, and denialism set in, RCAP, various court cases. All of these were moments of transformative promise that didn't deliver. And the chart kind of shows the acceleration of, in recent years in particular, the last 5 years with Chilcotin Nation and others being pivotal elements of this, the acceleration of those focus on the transformative shifts, on putting in, developing together, you know, major shifts in legislation, policy, and practice that can reset the foundations for the work. Now, so we see some of that building, we see the focus on that building, and we see the UN Declaration at the heart of this moment of transformation and change. You know, so this tension has always existed between the incremental and transformative, and the delays in getting to this moment. And to be clear, this moment is in a very nascent and risky stage still. I mean, we've seen little bits of legislation, certainly DRIPA in DC, and we'll see what happens federally after today. We have the languages bill and the child bill federally, but these are just the tip of the iceberg of the types of transformation that needs to be made. Both DRIPA and the federal bill, are very high level and do not contain the mechanisms and institutions and implementation frames that are needed to actually shift to recognition-based relationships that are actually reconciling sovereignties on the ground. And so this challenge remains, though the shifts are starting to come. And so this moment in time that we see in this chart obviously has had massive costs. Of course, the human costs are the main ones on the lives and harms and the maintenance of the legacy of colonialism on the ground in communities and families and the lives of children, youth, and women. That is where the heart of the costs have been. It's also had costs that relates to the questions that I was asked to write about. One of the costs is that it has delayed real grappling with one of the tremendous legacies of denial and colonialism, which is the refusal by governments to actually grapple with the original sin on the land side and in relation to title and territory. And I trace this doctrinally in the paper, and I'm not going to go through it here, but that original sin, of course, was the Crown assuming that it held property rights over lands which it didn't, and that it could pass on something to third parties, to other governments, to so on, that it didn't hold. And so there's a domino effect that traces, and in effect, Chilcotin lays out the reality of this domino effect of a property right wrong, a title taking that had no legal foundation to it. And then that domino runs through all the property rights that exist right till today in Canadian law. It's passed on and it's passed on. The failed grappling with that, throughout this period of time, the incremental transformative dynamic and the failure to make the real shifts to grapple with that reality over decades has created massive uncertainty and massive liabilities and greater complexity through the delays in grappling with it and dealing with it. And that's what the paper lays out, is that reality. Both Chilcotin and cases subsequently, like the Sycoos and Stellatin decisions here in British Columbia, reaffirm in ways that have been known for decades and is the reality of the common law, that title exists where it exists. It makes no difference whether it's declared by a court or not, or formally recognized by the Crown. Its existence, and therefore the taking, as the elder said earlier, the taking of those lands and resources without consent is wrong, always wrong, regardless of what the court says or hasn't said yet. So that's one of the costs of the delay. The other cost, which also relates to the specific topic today, is this fight to put the transformative foundations in place, the struggle, the leadership that Indigenous peoples have had to show, and the intense advocacy that has had to go into reaching these transformative moments and not having the promise met, has really diverted a lot of attention away from the vital work of rebuilding nations and governments and revitalizing their internal legal systems. All of that work being fundamental for the self-determination and self-government work that Doug talked about earlier, and I'm sure Paul and Cheryl will as well. I know Cheryl will speak, I'm sure, from a community level about the vital work going on. And this kind of struggle, this kind of denialism has really delayed seizing that work. I mean, it's at different places and led in different ways in different nations and communities, but it's also meant nations have had to focus their resources in places that they shouldn't have to. So these are some of the costs of this pattern and some of the promise of the space that we're in now. If we could flip slides, I'm just going to speak to one more slide about consent, then go to the next one, because I don't want to take too much more time. So the question I was asked was about the role of consent in all of this, then the property, that domino effect. And the reality is that consent can operate now as a bridging mechanism to grapple with this reality about property rights, this original sin and the domino effect, and that the entire system of landholding in Canada has a highly questionable legal foundation to it that has to be normalized. And the only way to normalize it is in a bi-juridical way, a way in which Indigenous legal orders, as well as the common law, are authorizing systems of decision-making on it and over it. And it's on that, so that's the first point in thinking about consent is not some consultation plus. It's not just adding engagement or adding steps or involving people a bit more. It needs to be a systems of decision making that are authorized jointly under that includes authorization through the Indigenous legal orders and the concepts that animate them. And I talk about that in some length in the paper, and that's a bigger topic for another day. The second point on consent is what models of consent look like. And fundamentally, and I know Doug has talked about this in some of his papers as well, there's only 3 models of consent under which there can be countless iterations of how you design it. And this will become relevant to DRIPA and the mining context as well. And so this chart just is these 3 high-level models of consent. The first 2 models, 1 and 2, these are models where consent is established through the relationship between the 2 governments and the legal orders and how they organize things between themselves up front. It's not about the decision at the end of the day. It's about the decision-making relationship between the 2 governments and legal orders that's established at the outset. So model 1 is simply to acknowledge the jurisdiction that's going to make the decision. So over in this area, over these lands, over these topics, the Indigenous government is the sole jurisdictional authority, and that's that. That's one way to establish the model. The second model is to jointly authorize under the respective legal orders a body, a joint mechanism that will make the decision together. We don't see many pure models like this yet, but that is another way to design it. Certainly this is being talked about relevant to this discussion in the mining context in BC and some parts of the province. I wouldn't be surprised to see models in this number 2 of consent, which under DRIPA would be authorized under Section 7 of the Act, to come out publicly within the next 18 to 24 months. The third model of consent is where the Indigenous and Crown decision makers are making their respective decisions separately, but you have basically absolute clarity that you need 2 yeses for any decision to go ahead, and you only need 1 no for a decision to not go ahead. And you have clear mechanisms to try to resolve differences at the end, but the decision of the Indigenous nation is the decision. If it's a no, then nothing proceeds. If you have 2 yeses, then it does. I could talk much more about these 3 models and operationalize them and how they're be operationalized. I'll just say this. DRIPA in Section 7.1a and 7.1b adopts expressly models 2 and 3 as possibilities. So that's the clause that talks about the making a statutory decision jointly. That's number 2. And then, or models where Indigenous consent is required before a statutory power of decision can be exercised. That's model 3. DRIPA, in the way it was structured, doesn't contemplate expressly in Section 7, Model 1. We could say something about that later on in the Q&A if you want. Anyway, this was a very quick, broad brush about discussions about consent that we could take many hours on. But basically, this connects to the issue of how to operationalize consent in this long-delayed, complex property rights reality. Where the land realities haven't been addressed. The original sin remains and the domino effect remains in place. And it's how to bring consent into a principled foundation to be a bridge in this context. So I'll just leave it there, and I look forward to hearing from the other speakers.
Thank you very much, Mr. Dinesh. At this time, I'd like to turn to Dr. Cheryl Lightfoot. Dr. Lightfoot is a Canada Research Chair of Global Indigenous Rights and Politics, an Associate Professor in both First Nations and Indigenous Studies and Political Science at the University of British Columbia. Her research interests include global Indigenous peoples' rights and politics, Indigenous diplomacy, social movements, and critical international relations. She publishes articles in both Indigenous studies and international relations venues. Her book, Indigenous Global Politics, was published in 2016 and is an extension of her PhD dissertation, which won the 2010 Best Dissertation Award in Race and Ethnic Politics for the American Political Science Association. She's Anishinaabe from the Lake Superior Band of Ojibwe, and she told me her community Kiwanis. I need more practice on that one too. But thank you, Cheryl. Over to you.
Thank you so much, Val. And I want to express my thanks to this group for including me in the discussion and acknowledge the distinguished speakers that I am so privileged to be appearing with on the panel this morning. And I do have, because I'm a professor, I have some PowerPoint slides to help outline my discussion today. So if we could give me the co-hosting possibility, I'll go ahead and begin my intro remarks while that is getting into place. So please let me know when I have the co-host so that I can run the slides. As Val mentioned, I am a professor at University of British Columbia, and I actually hold appointments in 3 departments at the moment. So I'm with the Department of Political Science, the School of Public Policy and Global Affairs, and then also in First Nations Indigenous Studies. And as an interdisciplinary scholar, my PhD is in international relations within the larger discipline of political science, but I take an Indigenous community-based approach in my work. So you'll see that in the paper and the presentation that I have today. And the focus of my work, primarily in the last dozen to 15 years, has been the implementation of Indigenous human rights in practice. And this is what I'm going to speak about this morning. Again, if I could get the co-hosting, then I can share my slides. Thank you. So the question that I was asked to contribute to for this larger project has been, how have Indigenous governments established particular mechanisms to include community members in expressions of consent? And the specific questions I was asked to grapple with are, what are the mechanisms and the opportunities that are available to incorporate and reflect community perspectives in mining review and consent processes? And then secondly, what are the measures that Indigenous peoples may wish to take in order to support unified approaches by communities to resource development issues? So essentially, I was asked to look at particular examples, case studies of various approaches to community-based processes and governance. And so I looked at examples not only within Canada, but particularly important, I think, for learning from case study work is that I also drew significantly from active cases outside of Canada. And I hope that these can be informative to all of us as we begin to work this out operationally. So just a few key background points. I think when we look around the world, we see that Indigenous peoples are increasingly working to establish their own policies and procedures for what they mean by FPIC. And to me, this is a very encouraging development because they are codifying their own Indigenous laws, their own governance rules, into particular consent policies and protocols. And I wanted to draw particular attention to the 2018 study by the United Nations Expert Mechanism on the Rights of Indigenous Peoples, who looked at the issue of FPIC around the world and found that these developments are particularly notable in North America, both in Canada and on the southern side of the border, and then a whole host of countries in Latin America. And you will see that the Latin American cases are featuring quite prominently in my paper and my presentation today. And so these protocols that are developing, policies, protocols, procedures, help establish the how, when, why, and whom should be consulted from Indigenous peoples' perspectives. And I looked in particular at a School of Law from the University of Middlesex, actually in the UK, and they've been engaging in a large research project that they have, it's been several years in the making, but their first publication came out last year in 2019, and they've been looking particularly at this question. So what are Indigenous self-developed FPIC protocols? And they've found 20 different countries where this is happening. And in their study, they have found that there have been 3 waves of consultation protocol development. And the first wave that they identified is one they've called the Principles, Policies, and Guidelines wave. And what we'll see is that this is particularly focused on Canadian First Nations, and most of the examples are there. And they have found especially in the beginning about the early 2000s, that this was a development strongly in Canada and notably in British Columbia. So a few examples that they give us are the Tahltan Development Policy from 1987, which included both impact benefit agreements as well as environmental impact assessments. And then there are several other First Nations in BC and into Alberta and Saskatchewan that are also highlighted in their study, along with the James Bay Cree mining policy, which I believe Paul may be speaking to us more about, Squamish Nation FPIC mechanism, and then they've also identified a nation in the Philippines that has developed their own guidelines that are very similar, in fact, to what we are seeing in Canada. And then I looked to some of the recent scholarship on FPIC development and found some important work by Martin Papillon and Thierry Rodon, several papers that they've drawn on, but I particularly referenced their 2017 work, which takes a close look at the difference between IBAs, impact benefit agreements, and EIAs, or environmental impact assessments. And they make some strong arguments about the fact that, in their view, IBAs create, used alone, a truncated version of FPIC, and that FPIC actually requires much more substantive participation in the decision-making based in community processes and deliberations, and coming from the community itself, not strictly leader-based or elite-based. And they see that the environmental impact assessments can provide that necessary deliberative space because they are based in community deliberations, openness, and transparency. So they are advocating for a 2-pronged approach that combines the strengths of both of these processes into a larger community-based process. And so they draw particular attention to the Secwepemc Nation and also Squamish Nation in BC, who have established such a two-pronged approach. Looking further, and there was a second wave that the larger study, the Middlesex study, found, which was on biocultural protocols for FPIC. And I chose in this paper not to place a lot of attention on this particular wave, but move directly into the third wave that they identified, which is the self-determination wave. And this is most strongly coming from Latin American countries. And what the researchers have found in their wider global study is that these types of protocols are grounded not only in human rights law, but are codifying specific indigenous laws and governance rules coming from individual communities. So they are as diverse as those communities themselves. And yet there are some common features that we see when we look at this set. So we do see preconditions for good faith negotiations emanating from the community and being articulated by the community. We see in most of them an articulation of what appropriate timeframes will be for discussions, as well as the stages of negotiation. There is usually an articulation and specificity around what the legal basis is and concepts, practices, and principles that from the community's perspective are non-negotiables. There is generally some particular guidance on who are the representatives from the community who have the authority to do the signing and the actual negotiation. So that is, again, articulated from the community itself, not decided by government. And then there is usually a system in place for how decisions will be taken within the community. Will they be on a community by community basis? Will there be a referendum? Will there be a general assembly? Whatever that decision-making vehicle is, it's articulated in these protocols. And then again, because this is reflecting the diverse cultures and contexts of each of the nations and communities that are engaged in these, in developing these, there is huge variation in terms of the focus and the format and the nature of the processes. So a few case study examples, and I invite you to read the paper because I go into quite a bit more detail of these individual protocol and process documents. And so you can read some of that more detail in the paper. But the Jiruna of Brazil have notably a two-stage consultation process and have been involved in co-developing their own consultation plan. They define principles of how negotiations will be conducted. They have a strong emphasis on transparency because they want everyone in the community to be aware of what is being discussed and agreed to, not simply the leadership. And they have a particularly significant and I think unique mechanism for balancing the power of their three villages that make up their wider nation. And one of those villages is significantly larger in population than the others. And they were sensitive to the idea that one village would have more voting power if there were a full referendum or a process of General Assembly. So they have developed a system to give each village a equal share of the voting on a village basis. So there are actually 3 political actors rather than the full population base. So it's something to consider and put on the table. And then they outline who are the legitimate representatives of their nation that should be interacting with government or industry. Another example is coming from Colombia, the Embera Chami. They have had a regulatory framework in place since 2012, including a particular FPIC protocol that governs mining. And this is one of the first indigenous developed protocols that we have seen around the world. And they are unique because they place a particular emphasis on ceremony and spirituality in their decision making. Then moving over to Peru, we have the Wampi. And the Wampi were one of the first, actually the first autonomous territorial government with a statute to come into existence in Peru. And that statute is including a FPIC protocol that is, as of the writing of the study, still under development, but coming close to completion. And it provides decision-making, again, to the overall Wampi government, not to the individual communities, because they are particularly sensitive to a divide and rule strategy. Shifting back to Colombia, another example, this particular protocol is grounded in indigenous customary laws there and their self-determination. This mechanism operates, again, simultaneously at the community level and then also through a general assembly mechanism. And they articulate a specific requirement that whomever the elected leadership is or the designated leadership is, there is a responsibility that they must consult with all of their traditional leaders and authorities. Coming back to British Columbia, I want to draw attention to a few, not mining, but other areas where Indigenous governance is beginning to come strongly into play, which involves water governance and watershed governance. And so we see, again, a few nations that have developed their own protocols in that issue area. So what are the commonalities that we can draw from all of these different case studies? And there are a few, and so I want to close my formal remarks by drawing attention to these particular aspects that we see across this huge variation of active case studies. So we can see that, above all, there is a move to self-designate who the representatives are that are authorized to do negotiations, who are the leaders, is coming from the Indigenous nation itself and not from government. Secondly, we see a huge emphasis across the board on inclusive participation. So women, youth are all part of the process and all part of decision making, although the mechanisms for how this is done vary significantly. And we can say there is no one size fits all model because they are unique to each one of these nations' contexts, cultures, and social orders. Thirdly, we see multiple coexisting authorities. So there can be several governing authorities that coexist, and these often manifest, and we're familiar with this in Canada as well, between elected and traditional leadership. In some parts of the world, these are defined by gender. In other parts, they are not. But where multiple governing authorities do exist, the FPIC process absolutely must involve all of the relevant authorities within the nation. And then each community determines for itself how to include those structures in their decision-making processes. And then finally, a heavy emphasis on consensus building and consensus decision-making rather than voting. There were only a few cases in the Latin American studies I found where voting in the Western way came into play, and that was actually considered a final option. If all consensus decision-making processes failed, they had a mechanism for going to a vote. But as expressed in their protocol, that was considered a failure in most respects, that the preferred method was through consensus building. and a strong recognition that these processes take a great deal of time, but they are culturally appropriate when they do happen, and they remain therefore self-defined by the community and not imposed by industry or the state. So I'm going to leave it there. I have much more material to discuss in the Q&A, and I look forward to hearing the last speaker.
Thank you very much, Cheryl. And if you wouldn't mind, there you go.
Yep.
I just want to remind the attendees and participants that these papers, as Dave said, are going to be posted on the First Nations Energy and Mining Council website, so FNEMC.ca. I just took a look, and the last week's papers are posted in the resource section of that website. I'm also just going to remind you that this session is being recorded, and it will also be available on the First Nations Energy and Mining Council website. At this point, I'm very happy to welcome Paul Joff. And Mr. Joff is a member of the Quebec and Ontario bars. He specializes in human rights concerning Indigenous peoples at the international and domestic levels. Since the early 1980s, he's been actively involved in standard-setting processes, including those related to the United Nations Declaration on the Rights of Indigenous Peoples, the American Declaration on the Rights of Indigenous Peoples at the Organization of American States, and the Indigenous and Tribal Peoples Convention in 1989 in Geneva. For the past 3 decades, Paul has represented the Grand Council of the Crees, the USG, and more recently, the Cree Nation government. Over to you, Mr. Joff.
Thank you. Well, good morning, and thank you to Elder Larry Grant, Dave Porter, and of course, Val Courtois for chairing. Thank you for this invitation to participate in today's panel. It is a pleasure to join all of you today. It was also a pleasure to review the Broughton Fish Farm agreements and the Seashell Foundation agreement for the purposes of today's discussion. The specific question posed to me is, are there provisions in the Broughton Fish Farm agreements and the Seashell agreement that can support approaches to consent in relation to mining? The response in my paper is a resounding yes. Both of these agreements were entered into with the government of British Columbia, and both are highly significant. As requested by the First Nations Energy and Mining Council, the central purpose of my paper is to highlight approaches that can serve to support Indigenous consent in relation to mining and its impacts. Both agreements refer multiple times to the UN Declaration. Further, in matters relating to provincial jurisdiction, the BC Declaration on the Rights of Indigenous Peoples Act, DRIPA, would also apply. Now, in the Broughton Fish Farm agreements, paragraph 1.0 of the attachment provides for a consent-based process. In addition, paragraph 2.9 is the sole reference to the adverse effects of mineral resource exploitation, but it is far-reaching. It underlines Article 32.2, which Dave Porter had earlier referred to in the UN Declaration, and the state obligation to obtain free, prior, and informed consent prior to the approval of any project affecting Indigenous territories and resources. Further, it emphasizes that the articles of UNDRIP benefit from being read comprehensively and without restricting the application of UNDRIP to the work under this letter of understanding. Now, in the Seashell Foundation Agreement, it is envisaged that the Seashell Nation will participate in gravel and other mine operations in the medium, which is 5 to 10 years, and long-term, which is 10 to 25 years. At the same time, it is underlined that the Seychelles nation could, if there were breaches of the agreement, institute legal proceedings that a specific mining project violated the right of self-determination of the Seychelles people, undermined its means of subsistence and overall well-being. Now, the term well-being is not simply a word. Article 43 of the UN Declaration affirms, and I quote, "The rights recognized herein constitute the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world." And of course, if someone, sorry, I knocked my, sorry. Let me just continue. So in addition, Article 20 of the UN Declaration affirms that indigenous peoples have the right, I'm quoting, to be secure in the enjoyment of their own means of subsistence and development, and to engage freely in all their traditional and other economic activities. Article 20, paragraph 2 adds that indigenous peoples deprived of their means of subsistence and development are entitled to just and fair redress. In my view, the term subsistence includes both food and water, since both are necessary for survival and well-being. Now, Professor Daly Sambo-Duro has already provided FNEMC with her presentation on self-determination. My remarks on self-determination will be somewhat different but reinforcing. Since I've been requested to address consent as the primary focus, I will focus on certain key aspects. One key reason for highlighting the right of self-determination is that free, prior, and informed consent, or FPIC, does not originate with the UN Declaration. Rather, consent, or FPIC, is an essential and integral element of the right of self-determination. International law affirms that self-determining peoples have a right to choose. Thus, indigenous peoples have the right to say yes, the right to say no, and the right to say yes with conditions. This right is critical when faced with mining projects that undermine indigenous peoples' rights to resources, especially their right to subsistence. Canada ratified the 2 international human rights covenants in May 1976. That's about 44 years ago. Therefore, since that time, Canada has had an affirmative obligation to respect and promote the right of self-determination of indigenous peoples. This obligation is explicitly included in identical Article 1, paragraph 3 in these 2 covenants. In this whole context, it is important to highlight that consent, or FPIC, is not the same as a veto. Veto implies an absolute power, regardless of the facts and law in any given case. The term veto is not included in the UN Declaration, nor is the term included in the American Declaration on the Rights of Indigenous Peoples, which was adopted by consensus in June 2016 by the Organization of American States. The OAS is a regional human rights organization whose members include Canada, United States, and the states in Central and South America and the Caribbean. In regard to the right of self-determination, Article 1.2, that's paragraph 2, of the 2 international human rights covenants is a highly relevant provision in the context of mining. Article 1.2 emphasizes, and I quote, "In no case may a people be deprived of its own means of subsistence. So for example, since salmon is critical to First Nations in BC, no mining company or other corporate or government entity can tell you, well, we have seriously affected or wiped out salmon in BC, but you can always go hunt rabbit or a caribou or fox. In addition to this provision in the covenants, the American Declaration on the Rights of Indigenous Peoples, Article 29, Paragraph 1, affirms, and I'm quoting, Indigenous peoples have the right to be guaranteed the enjoyment of their own means of subsistence and development, and to engage freely in all their economic activities. Indigenous peoples are both international and domestic actors. They represent themselves at international forums, such as the United Nations, and regional forums, such as the Organization of American States, as well as in Canada. Thus, in today's world, it is increasingly essential to be or to become familiar with relevant international law and regional law, such as within the OAS. This is all the more important since the Canadian government tabled this morning in Parliament the United Nations Declaration on the Rights of Indigenous Peoples Act. Its preamble affirms Indigenous peoples' inherent right to self-determination, including the right of self-government. The preamble also highlights the relevance of sustainable development and climate change to Indigenous peoples. In October 2012, the Commission of Inquiry into the Decline of Sockeye Salmon in the Fraser River, which is sometimes called the Cohen Commission Report, cautioned, and I'm quoting, placer mining appears to have the highest potential to reduce early freshwater survival of Fraser River sockeye. The researchers reported that only one active metal mine in the Fraser River drainage is close to habitat occupied by juvenile sockeye salmon. Now, the Cohen Commission report added, it was beyond the scope of this inquiry to examine the underlying causes of climate change and how society can address these causes. However, I heard enough evidence about warming waters and the impact on Fraser River sockeye salmon to reach the uncomfortable conclusion that many of my recommendations and the Department of Fisheries and Oceans efforts to implement them will not improve the fate of the Fraser River sockeye fishery if climate change continues unabated. While it is increasingly evident that much too little is being done to address climate change, Cohen's warnings of the impending dangers to sockeye salmon means that this species is much more vulnerable than studies have shown. Fish farms, as you know, also pose a threat to wild Pacific salmon. All such increases in vulnerability need to be taken into account when assessing the foreseeable impacts of mining and other industrial activities. In regard to sustainable development, the most significant international instrument is transforming our world, the 2030 Agenda for Sustainable Development. To date, the 2030 Agenda has been reaffirmed by consensus by the UN General Assembly over 80 times. The UNGA has also repeatedly stressed the, quote, need to ensure that no one is left behind and to reach the furthest behind first, including Indigenous peoples, who should participate in, contribute to, and benefit without discrimination from the implementation of the 2030 Agenda. While the 11th preambular paragraph in the UN Declaration refers to sustainable and equitable development, a more extensive provision is affirmed in the American Declaration, Article 19, which Professor Doreau already addressed. So I'll just end with the status of the UN Declaration. The UN Declaration is a universal international human rights instrument that elaborates on the economic, social, cultural, political, spiritual, and environmental rights of Indigenous peoples throughout the world. To date, the Declaration has been reaffirmed 9 times by the UN General Assembly by consensus. No country in the world formally opposes the UN Declaration. This reinforces its legal status and effect. It is important to note that all international declarations do not have the same effect. As former Special Rapporteur James Anaya has underlined in 2010, quote, even though the declaration itself is not legally binding in the same way that a treaty is, the declaration reflects legal commitments that are related to the UN Charter, other treaty commitments, and customary international law. Further, renowned international jurist James Crawford highlights, and I quote, even when resolutions are framed as general principles, they can provide a basis for the progressive development of the law. Examples of important lawmaking resolutions include the UN Declaration on the Rights of Indigenous Peoples. Similarly, other jurists emphasize, and I quote, examples of the most important declarations which have attained a quasi-legislative function are the Universal Declaration of Human Rights of December 10, 1948, and the UN Declaration on the Rights of Indigenous Peoples of 13 December 2007. Thank you.
Thank you very much, Mr. Joff. At this point, it's time for our facilitated questions, and I just ask our panelists to come back on to video, as well as our legal experts, Merle Alexander, Karen Campbell, Stacy Fox, to come on for that facilitated session. Well, Merle, since you weren't present in the session last week, maybe I'll turn to you first for some of your questions.
I knew I should have been there last week. I get double hit there, anyways. Of alphabetical and absence. A is for absence. Yeah, no, I mean it's been a really fulsome discussion, and I think one of the things that the BCFN Summit and the Union are really interested sort of in this particular discussion is sort of getting some guidance for ourselves about what are sort of next steps in the implementation of DRIPA. And of course, as many of the panelists have talked about today, we also now have Bill C-15 that was introduced this morning for the federal UNDRIPA. So DRIPA is BC, UNDRIPA is going to be the federal acronym. Neither one of them great, but you know, we live with it. One of the things that I've been particularly interested in, and particularly I think, which I think is a common theme to all three of the panelists, is hearing a bit more about their thoughts about the role of Indigenous legal orders in delivering consent. Because, you know, I think we're sort of like, we're sort of beyond just saying consent has to be the standard, because I think, you know, that's something that's universal, that First Nations are saying to proponents, to governments, And now the question is being turned and redirected back at First Nations. So what does that mean? So I'm sort of, I'm quite interested in sort of hearing what the panelists have to say about like examples that they've been involved in where nations have really sort of tried to dig into what exactly does their own law say about consent? Because I think it is universally concluded that Indigenous legal orders are consent-based, but I'm interested to hear from them what their experiences are on where nations are actually sort of doing that sort of hard work and digging into the topic.
Great, thank you for that. Mr. Alexander, any of the panelists would like to address that question? I see you're all taking extensive notes.
Yeah, just to clarify, Merle, in case I wasn't clear, all of the examples that I gave under the self-determination wave are all situations where those nations or communities, depending on the level, have adopted their own legal orders as part of the process. So at the moment, the majority of them are in Latin American countries and they are in Spanish, but that's not inaccessible to us. We can easily read them or find someone to gather them. And they have written them down, even though for the most part, Indigenous legal orders in those spaces are not written, they're oral tradition, but they have written them down so they're legible to industry and to government. And so that there is enhanced clarity about what the expectations are, what their own process is, so that government and industry there understands their timelines and that this can be an extensive process of community deliberation based on their own legal orders. And so they are extremely clear up front that this is the expected timeline, but it can vary significantly because they're going to do their own internal process based on, again, their own orders, their own laws, their own governing institutions. And within the scope of my paper, as I mentioned, they vary tremendously and they're unique to each situation. So gender plays a different role in each one, depending on the legal orders and governance norms of those nations. Youth play a different role, elders play a different role, and each and every one of those, and I've gone through very quickly each case in the paper, but I have much more extensive spreadsheets that go into intricate detail about each one of those, and I'll be happy to share all of that original material with the group, because I think when we start talking about next steps or what can that look like in BC, we have a few examples that are emerging that I've also highlighted, but looking to Latin America at this particular juncture is going to be extremely informative.
Thank you, Dr. Lightfoot. I see that Mr. Dinesh is unmuted, and then we'll get to you, Mr. Duff.
Sure. I mean, I can just, to Merle's question, and I'll just connect it to Paul's presentation. So, for example, he was talking about the Seychelles agreement. I mean, Seychelles, in the lead up to that, passed its decision-making law and policy for the territory as a whole. And that was a major driver towards the agreement, and they implemented it quite aggressively with industry and the Crown. It was supplemented with other pieces, including their own land use plan and so forth. And those were the stages. And then I was actually the negotiator for Seychelles in the agreement Paul was talking about. And so a major part of pushing that agreement forward was ensuring that all of those elements of their law and plan and its authorities were recognized in how that agreement and the milestones were being laid out. Having said that, though, and there are other examples of nations, certainly, and Cheryl alluded to them, developing their consent regimes over their territories. Different terminology used. Some nations have brought them out publicly, some have still kept them internally. But I will say we shouldn't have any illusions that principled, I mean, that's all vital work and it advances it. Governments still are driven more out of crisis than principle in all of these scenarios. So even in the Seashelt example, which was a new model of agreement that I know Lake Ravine recently completed one as well, they had all those pieces in place. They had a title lawsuit that's the furthest along with the Haida one, other than Chilcotin and Delgamuukw. But it was still crisis that forced the province to the table and drove the outcome. And that, honestly, that remains the reality. So that connects to another part of your comments, which we can talk about later, which is what really needs to be done to implement these pieces of legislation now in a principled manner.
Thank you, Mr. Dinesh. Mr. Joff.
Good. Well, there are a few elements here. One is the role of Indigenous orders in determining consent. And Doug White mentioned the concern of ensuring that there's the appropriate constitutional space. So that becomes a critical factor. Now, to get that space, it's very helpful that the UN Declaration and the I think the new legislation repudiates colonialism and the doctrine of discovery and terra nullius. The Chilcotin Nation case in 2014, the Supreme Court of Canada repudiated terra nullius. I'm just doing it by memory, but I think it's paragraph 69 because it was pretty significant, but they didn't go all the way. And so if one uses the new federal legislation once it's in effect, and we have to get there first, but also the UN Declaration and the American Declaration, and we assert the right of self-determination, which certainly deals with the right of self-government, that's included, that may be a way to get there. I'm not saying the path is easy, but I'm saying that we have now a strong argument within Canadian law, and we have a strong argument or path to take in international human rights law. And of course, one should always keep in mind that the minimum standard between the UN Declaration and the American Declaration on the Rights of Indigenous Peoples on any given issue, it's the one that has the higher minimum standard. So one cannot anymore just look at the UN Declaration. It may well be that the new minimum standard is the American Declaration. And of course, the American Declaration was also adopted by consensus at the OAS. So all these are strong ways to fit into whatever other arguments Indigenous peoples may have.
Doug, I see you want to add a comment. Please go ahead.
Thank you, Val, and thank you, Merle, for the question. I think I just wanted to comment. I agree with what people are saying, of course, but I do hope that Indigenous leadership, this is going to be enormous work internally inside of each Indigenous people to undertake. And so there's definitely going to be a very important inward focus to articulate. And as Cheryl, I think, very rightly put, what's important is to somehow articulate largely unwritten laws in a way that can be apprehended by the Crown and by industry and the public. Part of the fear of, this issue, the way that I think about this is that the Indigenous self-determination is sort of one of the big sort of boogeymans of the Canadian imagination. This is stuff that scares and totally frightens the Canadian society, the idea that Aboriginal peoples have a say and can make decisions. It has not been part of the tradition in any way. Part of that that fear is simply a lack of knowing and understanding. And we all know from our side, from living our lives with our people, that the Indigenous legal orders and traditions have continued full force. We know how they operate. We know how they work. We live in accordance with them when we're getting married, when we're naming our children, when we're going hunting and fishing and doing all of the, when we're being simply who we are as people. We're living in accordance with and through understandings of those legal orders and traditions on a regular daily basis. When we think about our relations with each other between Indigenous peoples, the framework that we operate from is from our Indigenous legal orders and traditions. So we know that they continue. We know that they're relevant to our lives. Of course, the challenge is that people other than ourselves are largely completely ignorant of them. And so there's a lot of work to be done in that regard in articulating. Now, and that's going to be internal work. But I do want to impress upon Indigenous leadership what I think is a very important joint project of all of them in this province to develop a comprehensive joint strategy in bringing about these frameworks in the most powerful way. Don't do this by yourself. Like, don't, obviously there's internal work, but make sure that we're standing together when we can and that we've done the work that's necessary to articulate a broad, comprehensive shared strategy and framework and reorientation so that as we go through this work over the next number of years, and some nations are obviously well ahead of others, that no one's left behind and that we're doing this shoulder to shoulder and that we have clear political, legal, economic strategy that we share together. So really encourage BCAFN and the union and the summit and whatever other spaces like through the Energy and Mining Council that you facilitate the development of that joint collective strategy. Because without that, I mean, I'm the chief negotiator of Lake Babine Nation, and there wasn't a particular crisis that led to, it was very hard work bringing British Columbia and Canada to the point of getting to the foundation agreement in September. And in that agreement, it says that, it's basically it's a framework agreement that has some very important immediate benefits. Some of them are, the shifts that are necessary to get to consent, but full commitment to negotiate the self-determination for the Lake Babine Nation, but also the implementation of Lake Babine Aboriginal title. And so this is, in terms of Roshan's, one of Roshan's charts that mapped out that the trajectory that we've all been on. This is, I think, a very important development and opens up new space, and it's where the Crown is saying clearly, one of the earliest times they have that they're willing to do this work and that we're on a fundamentally new path. But I do think, though, that it's very important for leadership to find alignment and to talk to each other about this project and this work. So I just wanted to add that. Thanks, Merle, for your question.
Thank you, Doug. And I see, Cheryl, you have some comments to add?
Thank you, Val. Just a couple quick add-ons after hearing the other responses, just from a comparative lens looking globally. Paul mentioned that we have the constitutional space here in Canada to be doing this. There is one other country that also has constitutional space that is part of my case studies, which is the country of Colombia. So while it's not quite as how could we say, operationally advanced as Canada and always up for different sorts of debates, it is in a legal framework something that we can also look to for how to maneuver on the ground conditions that acknowledge that constitutional space. And then I just wanted to also loop back to Roshan's 3 models because I wanted to draw some comparative attention to some cases of Model 2 because Roshan said the jointly authorized body is not so well developed yet here in Canada, but we hope to. There are 3 notable models of that going on in Aotearoa and New Zealand. I think we've all probably heard news in the last few years about the Whanganui River negotiation, the settlement there that gave the river legal personality. And that's significant, but what's also significant is the governance mechanism that has been co-developed between that iwi and the central government as well as the municipalities is a co-governing body over the river, and it takes the form of guardianship, but the actual mechanism for how that is operationalized as a jointly governed, jointly managed space is particularly instructive for us. And then there are two less known cases in Aotearoa, New Zealand, that have come about since Whanganui River. One of them involves a national park, which also has a co-governing body. And then the newest one is the Mount Taranaki settlement down on the southwestern portion of North Island. So I would draw everyone's attention to those as particularly fulsome examples for development of Model 2.
Thank you very much. I know Karen has a follow-up question, but before we do that, Merle, I just want to give you a chance to ask any associated follow-ups to your original question based on the answers from the experts.
Yeah, again, thanks very much for all the answers, panelists. I mean, I think that the common theme, which is sort of already sort of, I guess, a pre-existing conclusion for me, is that we need to invest. We really need to invest a lot of time and effort into the capacity building element of sort of reinvigorating Indigenous legal orders. Because I think, and I have like a few thoughts about hearing what the panelists are saying, which is, I think we really need to, and this might be more commentary than like follow-up question. I think one thing we really need to avoid with this focus of reinvigorating our Indigenous legal orders is, one, not to have it completely driven just to answer what is consent, which I think a number of the panelists have touched on, including Paul. That we have to not take a duty to consult approach to invigorating or lifting or uplifting our own laws. It has to be something that's driven at the nation level by right holders themselves, and it not just be purely reactive, which is what the duty to consult does. It always has us on our heels trying to react to whatever proponent or government is asking of us, and then through that filter we tell them this is what our law says about that. Instead, we really need to take like a much more pure self-determination approach to things and build laws based not on sort of anticipating what other external parties have, but really truly what is the laws of our peoples. I mean, part of the I think the artificial element of just sort of saying taking consent in the mining context is that in itself already sort of has like a double filtered reactive element to it, where we're like, what can we tell the mining industry or the exploration industry what is consent to us? And I think like we just need to sort of start off with a much more broader element, a broader approach to that, which I suspect is partly the approach that was taken in Sishoth, where it wasn't just purely driven by trying to answer to someone else. It was intended to be something about just affirming that core element of self-determination. So I guess I mean, if there's anybody who has any sort of additional comments on that, I just think like that was sort of running through my mind when I was listening to the speakers discuss, is that we have to really resist it just being a duty to consult approach where we're constantly reacting to what others want from us, and really sort of say this is our law. We're going to just sort of reinvigorate this, not for this proponent, not just for this generation, but something like a really truly self-determination approach.
Thanks, Merle. Any additional comments or responses from the panelists? Doug?
Yeah, just really quickly, Merle, I think that's very important to ground the work, not sort of aim fully at consent, but that it's about expressing self-determination of Indigenous peoples and occupying the landscape and occupying the field. I think that, I mean, as an example, within our Indigenous legal orders and traditions, we largely have land use planning as a major element. We know what the landscape is, what our relationship to it is, what areas can be used for what kinds of activities. And the sooner we're articulating that in ways that are that can be apprehended by the outside world, the better. And I think it becomes that kind of an activity where you're proactively sharing your relationship with your territory in a way that shapes the way that proponents even think from the very beginning about your landscape, and as well the Crown, and that that consent is it becomes embedded in that broader framework. It isn't just, as you say, reactionary. So I think your point is dead on in terms of the way that this work has to be approached.
Thanks, Doug. Mr. Dinesh, did you have additional comments given the reference to the Seychelles process?
No, not at this time. I mean, I just reiterate what Doug said. I think how Merle lays it out is, I mean, that's the fundamental work. And those nations that are rebuilding in that way and putting those down, I think, lay the groundwork, the necessary groundwork to force the Crown's jurisdictions into the proper relationship. And I think that's what we see consistently, where the breakthroughs have been.
Great, thank you. Karen, over to you for your question for Cheryl.
Great, thanks so much. And thank you all to the panelists for the presentations. I'd like to pick up on a piece that Cheryl has talked about, and it relates to the different jurisdictions and all of the different processes and the models that she's found. And I wanted to just ask a little bit about the role of the state in all of this. So obviously Indigenous legal orders have the work to do to come up with their consent frameworks. But to what extent is that work of FPIC or consent, to what extent has it been influenced or triggered by the state? So in other words, the communities that you've looked at, did they do it of their own accord? Was it an internally driven process? Or were there state activities that helped or hindered the development of that? And I think that it's very relevant because, like, what's the role of the state in the quality of the process? And in theory, there should be none, but in this reality, what is the role of the state in the quality of the process? Are the states generally, are they neutral? Are they supportive, or are they hostile? Because I really do think there is a duty on the state or the Crown in BC to make sure that it is doing its level best to support the development of any kind of process or protocol. So I just wondered if you can comment on that from the other jurisdictions perspective. If any of the other panelists have comments they want to make from a BC perspective on the role of the Crown, that's welcome, but it's primarily directed at Cheryl just for that interjurisdictional comparison piece. Thanks so much.
Thank you so much, Karen, for the question. And it's an important one because it varies quite a bit. And what I did find as a common feature in the cases that I looked at in Latin America is that there was a triggering event of some kind that began the work of articulating the legal orders into an FPIC protocol. So it varied. Sometimes it was the beginning of a mining process, and it was actually in one of the Colombian cases that I wrote about. The triggering event was that the nation, the indigenous nation, discovered that the state had already issued 48 mining concessions in their territory. And so they stumbled across this as a very unpalatable finding. And then they set to work on designing their own protocol. They did GPS mapping, they established their own territorial boundaries. And so because they protested with the government of Colombia, the mining processes had to stop because of the legal framework in Colombia while the nation worked out its own FPIC protocol. It has not been what you would call well accepted necessarily by industry. and the state. They would prefer to have proceeded with the 48 concessions that they had originally granted. So it is a bit of a hostile environment. In a few other cases, it comes from a historical experience, particularly in the Amazon. There is a long history of encroachments on indigenous territory. And so the groups there had the historics in mind and were anticipating that there would be mining activity and timber activity in their area. So that was a little bit different case. And so because most of these are just in their final stage of articulation in terms of a written document, a lot of the reception by states and industry is not yet well known. So it's an evolving issue that we have to watch very closely. And the states in Latin America will vary significantly on their receptiveness. I would expect right now, if a Brazilian group came forward with their own FTIC protocol, that would be summarily dismissed by the Brazilian government because it's a very right-wing populist sort of government. And yet other places like Colombia or Peru or Ecuador, Bolivia may get a much better reception and would have a more difficult time casting aside an indigenous developed self-determined based protocol. And so it's going to vary. I would put the British Crown, the Crown as we know it, more in the receptive category. I think they would have a hard time dismissing or ignoring something that was self-determinedly developed within a particular nation, and they would have to deal with the public reputational impacts of that in ways that, like the Brazilian regime, can just feel that it can cast off. So wide variation, and again, I can give you a more fulsome and in-depth comparative analysis if you would find that helpful, the different cases in Latin America. Karen.
Great, thank you. Cheryl, any other associated responses from the other panelists to that question? Mr. Joff.
Thank you. Yeah, going back to what Merle said and also Doug, when Section 35 was put in the Constitution in Part 2, basically the Supreme Court made up the duty to consult. There are no words there that says it has to be just consultation. So what we have as minimum standards, whether you look at the UN Declaration on the Rights of Indigenous Peoples or the American Declaration on the Rights of Indigenous Peoples, the minimum standard is consultation and cooperation. Cooperation right away brings in a consensual element. And the reason for it is that when we first started negotiating with states at the UN back in the early 80s, every region in the world where there were indigenous peoples said emphatically that consultation alone was not working. So it was the same all over the world. So finally the states raised the bar to consultation and cooperation. Now, if one takes the wording in this new federal bill, which actually is already law in Canada because it's in the Indigenous Languages Act, it says, whereas the government of Canada recognizes that all relations, not some relations, all relations with Indigenous peoples must be based on the recognition and implementation of the inherent right to self-determination, including the right of self-government. So obviously, it's still a challenge with all these different contexts, and we're still dealing with colonialism, but certainly some of these new provisions combining, what's in the new federal bill, what's in the UN and OAS declaration, the American Declaration, we can get out of the box of consultation and move to a higher level. Thank you.
Thank you very much, Mr. Joff. Maybe at this point, I'd like to turn to Stacy Fox and Zerza for questions coming from her.
Thank you, Val. Stacy at Dirt to Fox. Dave and I have this long history of kind of switching my last names around. Thank you very much. Welcome, everybody. Hi, panelists, friends. I know you all, and I appreciate your words today and your time. I've got lots of questions around the consent piece and the legal orders, and maybe we'll have time to come back to some of that. But I'm going to switch gears slightly here. As legal counsel to the First Nations Summit and part of the First Nations Leadership Council legal team, we work with the province. We helped draft Bill 41, which is now the Declaration Act on the Rights of Indigenous Peoples in BC. And we've been engaged somewhat in reviewing what's now before Parliament right now is Bill 15, the federal law. We had less engagement there, but obviously we're paying close attention to it for alignment and consistency and with what we've done here in BC. But what I want to do is, Roshan, you alluded to new institutions and frameworks needed to actualize a shift in BC through the implementation of the Declaration Act. And I'm just going to ask you if you can elaborate on that somewhat, because we will be resuming our processes with the province imminently now that their cabinet's been sworn in. And we just passed the first year anniversary and we still don't have an action plan. We're still trying to figure out how to align laws and some of those process pieces. So I just wanted to pick up on that thread that you left hanging there to see if you had further comment.
Sure, thanks for that, Stacey. And just for clarity, because I have, as you know, I've been advising BC on UNDRIP implementation for the last year and a half. So I'm not here speaking, I'm just going to give my own thoughts. I'm not speaking for BC in any way. But I mean, the amount of legislative policy and practice change that's required, whether it's BC or Canada, is vastly more than what we see in either DRIPA or UNDRIPA if it becomes a law. And fundamental to that is really the need for mechanisms and processes that actually implement the shifts on the ground. And you can just start by going down, I mean, start with the obvious from DRIPA, which, you know, does have a few mechanisms in section 6 and 7. But I mean, I know what the issues are and the ones you're alluding to already. So the whole issue of consistency, laws, you know, taking all measures necessary to make laws consistent with the UN Declaration. Well, that's an obligation that exists as soon as that law came into force. So then you have two categories of mechanisms that you need, which we don't see yet. One is you need what's the mechanisms for new laws? There's a whole range of mechanisms that could be in place to ensure consistency, whether it's expert bodies you establish, whether it's requirements on what the Attorney General has to do to say in Parliament, whether it's right to the internal work of how cabinet submissions are drafted and prepared and what kind of analysis that has to go into them, to the broader work over time probably of having standing bodies or entities that you know, provide guidance or accountability around that. That's one example. You need a separate set of mechanisms and processes for what you're going to do with existing laws and what are the measures that have to be taken. I mean, no measures are not taking all measures necessary. Well, that's the situation we're in, right? We need to have measures on the books very concretely. Even take the consent piece. So the BC bill did do something novel, which is not in the federal bill, about creating the space for the legislated, for consent to be established and operationalized. And as I said, two of the models. You know, to implement any of those models through agreements under Section 7, you need further legislative change. So in the land and resource context, you're going to need legislative change in each of those statutes that says a statutory decision maker, irrespective of what's in this statute, Land Act, Forest Act, Mines Act, name it, must make a decision consistent with any agreement entered into under Section 7 of DRIPA, which would be the consent model that's in place. There's no reason to wait to make those amendments till after agreements are done. There are some agreements coming down the pipes, but there's no reason to wait. Those amendments should be made now so that when agreements are in place, everybody knows that that is the decision-making model for that nation and the Crown regarding those mining issues. Those are certain types of mechanisms specific to BC and more on the land and resource side. but fundamentally, you know, the federal bill, it needs around it, you know, it needs clear mechanisms, and this is more on the federal side, for how when nations determine and wish on their own terms through their own processes of self-determination, that there is a direct obligation on the Crown to recognize, I'm speaking in the First Nations context here, to recognize that Indigenous government and facilitate and actively do what it must do to dismember the Indian Act control over that entity and that reality and that nation and that people. Those mechanisms don't exist. It's hard to see how Articles 3, 4, and 5 can be aligned with any Indian Act structures and realities, but there are no mechanisms put in place for that. There's no obligations around the recognition. It's going to become an interpretive issue around the bill unless they move on that. And then there's the whole accountability and dispute resolution side, accountability and oversight of the governments in implementation. There's allusion to it in the federal bill in Section 6 2B, I think, that it has to be in the action plan. But are we going to have robust accountability that actually has oversight of that implementation, or what is going to look like? That's going to take structure, it's going to take independence, it's going to take joint development. And then there's the whole dispute resolution side, which I don't want to get into because I've spoken to it about elsewhere. And Stacey, you know about the commitment document, of course, since you helped write it, and the work that has to be done in creating institutions on that side. So maybe I'll just leave it there so others can speak, but thanks for the question.
Do you have comments from others, Doug? No? Follow-up question, Stacey?
No, I really appreciate that. It just reminds me of how much work we have to do, but maybe not a question, but a comment. I've always wondered if, you know, the relationship with the Crown needs to kind of restructure itself as well. The way they've been structured and have engaged with nations hasn't always worked, and it's set up barriers, and not that you have to answer that, Roshana, give comments, that's great. They're talking about a secretariat now in regards to the new Declaration Act. I'm not sure what it's going to look like, what its mandate will be, what its design will be, or anything like that. I think it's positive in the sense that it signals a shift, that there's a recognition of institutional change needed. We'll see if it goes far enough. But, you know, back in the day when we did the new relationship and the commitment document, I'm dating myself here, but I'm dating a few too. We talked about an all nations, a Senate type body that would look at bills being contemplated, or could a secretariat be an Indigenous body of some sort to add some legitimacy to these processes? I just throw those out in case people do have thoughts, but if not, we can move on and hit some other themes in here as well.
Well, I'll just say briefly, we, of course, properly spent a lot of the discussion this morning on the work that nations are leading and must do as part of self-determination and self-government. And I mean, the Crown has a responsibility and a role to get out of its divisive functions in relation to that it's played. But to your question, Stacey, I mean, just as much the Crown government needs to get its own house in order to do this work. They are not structured or organized to do this work, and they don't have, you know, I often give talks, and some of you heard me talk about it, you know, they don't have neither the culture nor the structures internally to affect true and proper relations that we've been talking about with Indigenous governments and legal orders. That requires different kinds of people, new kinds of people, new understandings, new mindsets, new worldviews. It requires a culture of in-betweeners, people who actually understand and break down the silos between these different realities and ways of talking and understandings and experiences. And that is not there yet. I mean, if governments are serious about aligning with the Declaration, then they have to decolonize and realign their own internal structures and cultures in significant ways. And it's sort of a litmus test of seriousness, how much you see that happening or not. And that's something to push on and keep watching for.
Great, thank you, Rashawn. Any additional comments on that point by the panelists? I think you were getting a lot of agreement when you were talking, a lot of nodding heads from the other panelists. Merle, I'll turn back to you to see if you have additional questions for the panelists.
I don't. I mean, I don't have an. Oh, sorry. I'll let Paul. I see Paul stuck a finger up. I'll think while he's talking.
Yeah, I just said I don't mind whichever order you wish. Going back to Roshan's point about no institutions here that to develop this. Of course, Canada is very broad. I don't think it could come up in federal legislation with too much detail on institutions. But if we take the UN Declaration, because I'm looking at Section 5 of the new bill, and it says the Government of Canada must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure the laws of Canada are consistent with the Declaration. So the Declaration deals with Indigenous institutions. You have Article 5, right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions. That's one. And then you have Article 33.2. Indigenous peoples have the right to determine the structures and to select the membership of their institutions in accordance with their own procedures. So for a federal government, I don't think it can get too specific in legislation, but they've opened the door to having an obligation to ensure the laws of Canada are consistent with the Declaration. So I see Article 5 and Article 32, or 33, I should say, 33, as steps in that direction. How each First Nation, or even groups of First Nations, if that, a regional type context, that's up to each entity to decide that. I don't think, that has to come from Indigenous peoples. So it leaves it broad. It leaves you all the openings. There are provisions that say that there's a right not to be subjected to assimilation or destruction of culture. So the government, whether it's BC or the feds, can't come back and give you a kind of assimilative or some type of structure that would be, which would undermine you, either economic, socially, culturally. So I see it as pretty broad, but I do see an opening there. It's a big challenge. Obviously, it's a big challenge, but at least you have some legal ammunition there. And the, what was that case? It was in the Northwest Territories, but it was a judge who did make space and use the Declaration for Indigenous structures or Indigenous governments. I forget the name of the judge, but it's all happening, but it's up to you to fill it so that it fits exactly each nation or group of First Nations perspective and priority based on your own idea of self-government and self-determination. Thank you.
Thank you, Paul. Cheryl?
Yeah, thank you, Paul, for that. I've also taken a look at Section 5 of the new bill, and I'm quite impressed with what I see. And I also notice how many times we see the word must in the new bill. And so I appreciate that, that it is turning up the temperature in terms of pressure points from what we've seen in the past. So that's at first look this morning, some of the things that appealed to me, in addition to what you've already mentioned about repudiating doctrines of discovery and racial superiority, these are very strong statements, and I am very happy to see them. I just wanted to add a few quick comments about the question of political bodies or political voice and political representation, and the models that we think could be effective or desirable moving forward. This is a particularly active and open question across the Commonwealth. And a few different models are in play that I think, we can take lessons from. In Australia, and Megan spoke to this last week quite explicitly, the Uluru Statement from the Heart has advocated for a particular voice to Parliament that would be a single Indigenous voice to Parliament. That has been quite boldly rejected by the Australian government in a very disappointing way, and Megan can speak to that quite extensively and passionately. If we look to Aotearoa, New Zealand, there are a few different mechanisms that have been in play that we do not yet have in Canada that I think we should put on the table. The first is designated Maori seats in the Parliament. Those have been there since the end of the 19th century and have varied in their efficacy at times from being hugely significant to insignificant, depending on the political winds and culture of the decades that we've gone through, because they have been in place for a very long time. And originally, and some folks miss out on this in some of the academic conversations, those were intended to be a tool of assimilation, which is why when they came about in the late 19th century, they were specifically established in order to socialize Maori into the Westminster system, and eventually it was seen that they would be dissolved because they would be considered not necessary. So philosophically and contextually, there is that problematic element, but over time, and certainly since the 70s and 80s, those seats have become something that Maori are very proud of and want to maintain. So they have very much shifted in their orientation over time. And the other piece of the New Zealand political landscape that has been important, hugely important for enhancing Maori voice in Parliament, has been the proportional representation system, which New Zealand used to have a pure Westminster first past the post system. They changed in the mid-90s, and the results of that in terms of Maori voices in politics have been, since that time, absolutely phenomenal. So at the moment, at the last election, the Maori voice in Parliament far exceeds population parity. Maori are present in every single political party and ran in every single political party. So that is well on top of the Maori seats. But when you take them together, that is a political voice that absolutely cannot be ignored at any level. And so it's been the combination of those designated seats plus PR that has just dramatically over the decades amplified that political space. And yet, when we speak to our Maori cousins, they will tell us that neither of this is enough yet. They still don't have enough access to politics, enough access to political institutions. And so when I speak to some on-the-ground folks, they still want some sort of a body or a Senate that would fit into the system at that level. So I think when we look at those two cases and then our own context here in Canada, and I know BC has dabbled with the PR question not that long ago, just a year and a half at most, not even 2 years ago. And there was discussion at that time about designated seats as well. I think the lessons when we look down under are clearly that we need multiple points of political access, multiple points of representation, and quite frankly, the more the better. And don't rest on any single model, but put it all on the table and keep pushing for more.
Thank you, Cheryl. Roshan, I saw you had a comment.
Well, I mean, Cheryl, yeah, I'll just say quickly, Cheryl actually put a concrete example on the point I was making, which is about the changes needed in state structures and state political spaces. To Paul's point, I wasn't talking about the Indigenous governing spaces and models. I was talking about what needs to be done to ensure that these laws being passed don't go the way of what we have seen in those yellow transformative dots that I've seen in the past, which is that the state does the easiest thing, which is to do nothing. We have constitutional provisions that have just been forced to the courts for 35 years at immense cost to Indigenous peoples at all levels, in all ways. There is nothing that can guarantee any words on a piece of paper in any piece of legislation that can't guarantee that this will not devolve into court fighting for a decade or more about what these bills mean. That doesn't mean don't pass them. That doesn't mean they have tremendous value. I was deeply involved with both governments in moving aspects formally, federally, and then certainly provincially. But it does mean, as Cheryl just illustrated, far, far more needs to be done in terms of structural, political, cultural reform and change on the state side. We talked a lot about it on the Indigenous side, but ultimately, this work involves reframing and reshaping a lot of what we take for granted about how governments in this country operate and are structured to operate. And the question is the readiness to actually do that work and how it's going to get done. You know, as Cheryl said, we see many mechanisms moving forward in New Zealand, but we still see far more being called for. So the doorways that are being opened through these excellent pieces of legislation that are being passed, yeah, they form a principled foundation, a set of standards, but holding the feet to the fire and how to do that and giving structural and actual implemented effect on the ground, that's where the heart of the hard work's going to be. And that's what I was speaking to about the state change that's needed.
Doug, I see you lean in.
Yeah, thanks, Val. In my experience, the work of bringing about the kind of shift that's necessary is made very difficult by the lack of understanding and infrastructure and apparatus on the Crown side, and the deeply rooted patterns of denial that exist in both of those systems, both provincially and federally. This is enormous work. Like, there has to be, we have to help bring about a major sea change inside of both both the federal and provincial governments. That's essential work. And part of the work of Indigenous peoples has to be to help shape that and to guide that and give direction about how we believe the province has to be different, and what do they need internally to be able to become different. And so I think that's that's just as important as the work that we have to do ourselves on our side, is to make sure that we're driving and illuminating the pathways that the Crown, we believe the Crown has to be on to do this correctly. When Cheryl was talking about the participation in Parliament and all of that, I mean, the thing that I think that there's some value in that idea to think about. But for us, we have, in BC at least, we have such enormous diversity. It's hard to imagine how that would work. We're not sort of and I don't know much about the Maori people, but we're not the same kind of unified cultural context as in New Zealand or even in Australia. There's so much diversity here in BC. I mean, my understanding has always been that what we're seeking is the right government-to-government approach, and that there may be interstitial mechanisms that have to be built to coordinate decision-making and coordinate governance together, but that it's not. I mean, I've never imagined the general approach to be that we achieve some of the goals and objectives of self-determination or self-government, or even more broadly, just bringing about the change necessary by relying on participation in as MLAs or or whatnot. I think that the focus has to be, at least in the first instance, the development of the most powerful forms of self-determination and self-government that we can achieve, and that an important part of that self-determination and self-government is crafting and building the right relationship with the Crown on a government-to-government basis. And having said that, it may very well be that in the broader framework, that some of the ideas that Cheryl's put forward may make sense, but I think that the first emphasis and priority has to be on government-to-government, self-government-based focus. So I'll leave it at that. Thanks.
Thanks, Doug. Doug, I want to give Paul a chance to respond if you have anything to add. Mr. No? Okay. Merle, back over to you.
Yeah, I can't wait for Paul to raise his hand one more time. No, I'm just kidding. I mean, maybe taking us like back to something which is like, I guess, the actual subject matter, and knowing that with the knowledge that the next panel is specifically going to bring sort of mining experts like to the fore also. I mean, I think and also sort of noting that actually none of the, like right now in terms of implementation of DRIPA, we have yet to form a mining exploration specific subjoint core working group. So, I mean, I'm probably more like speaking as an individual here than as the organized, definitely not as BCFN. But I mean, some of my like original thoughts of things that we really, because I mean, I think one of the most important things is we have to make DRIPA implementation tangible, pointed, and even if you can, some things that are universal to all First Nations in British Columbia, which is like one of the things that I've been thinking from day one about implementation, particularly in the mining context where it's very clear that Aboriginal title is at jeopardy. Like the legal obligation to preserve the territory for future generations is at jeopardy in the exploration and mining context, particularly because of the very invasive site-specific nature of that industry. So I mean, I think like if you were going to sort of like pull an example, and maybe I think it's actually probably quite consistent with what was said in Delgamuukw and then again in Sokoteen, like examples of where title, like where the duty to consult and the appropriate standard is consent, it would be in the mining context. So I mean, I think trying to think about actual areas that we really need to sort of like dramatically shift things. I think that one of the core sort of implementation elements of DRIPA has to be, and of UNDRIP has to be that projects will not be approved without the free prior informed consent. And that is that it'll become a legal requirement. There's an IBA and a legal requirement that there is a Section 7 agreement, that's the consent-based agreement, with the relevant First Nations to the project, like as a starting point. So I think we could probably all universally agree that that is something that we would all agree should be like a shift. Then I think what follows from that is when you sort of say, okay, what does consent mean in that context? Then we go back to what we've been sort of thematically saying all along, which is that it has to be self-determined by the nation itself. And that would then hopefully trigger some true investment in the capacity building of nations to start developing what a consent-based decision-making model looks like for them. So, if that's a decision-making law for Seychelles, if that's specific water guidelines for the Yankadene, if that's if that means that Stramic develop particular consent-based standards for a very specific project, then that's it. But I mean that we need to have like, part of that does need to think, the precondition to that has to be that the key mechanisms which Indigenous people are engaging exploration and mining have to shift at the very top level to be consent-based first. And then then that requirement can sort of be spelled out at like, at sort of like the nation specific and even project specific level. But because, I think like one of the things I think that we really have to pull from like some of these panels is things that actually send strong communications to how things need to change, because ultimately that is like part of the, like that's the drive behind all of our work, behind UNDRIP, behind DRIPA, behind Section 35, between UNDRIPA, is dramatic legal reform. So, I mean, I'm interested to hear, like, from the panelists, what other types of things they think need to be changed, or if they agree or disagree with me about things that we think need to be changed. Like, I just think like things like ECTAs have to be replaced, Economic Community Development Agreements. They need to be replaced with actual true Section 7 agreements. And I'd be interested to sort of hear like what the panelists have to say to that. I'm sorry for those who are not from British Columbia and familiar with all of our many acronyms.
Thanks you very much, Merrill. Any of the panelists want to address his question and comments?
I'll jump in quickly. Just some quick comments. I do think, so, you know, I believe that since, at least since Chilcotin Nation, which is what now, like 6 years ago, 6.5 years ago, I think of that decision as sort of like a wrecking ball swinging through a legislative framework that's 100 years old and that is completely wrong-minded and is just simply incorrect. All of the basic premises of the Crown, that Aboriginal title doesn't matter, probably was extinguished, or if it exists, it's in small spots, that all of those basic ideas were swept aside and fundamentally rejected by the court. And in my mind, that created enormous tension in British Columbia. And I think about, I mean, I've been a bit surprised that there hasn't been to date a real urgent work being done in forestry, as an example, in the basic forestry tenure regime. You know, in 2002, we had the last major shift in the forestry tenure regime in BC through the Forest Revitalization Act and associated acts. I mean, effectively, the trajectory was to take the public forests of British Columbia, what they considered to be Crown forests, even though much of it was Aboriginal title forests. They took that and they turned it into quasi-private property and put it in the hands of forestry companies through changes in the tenure regime, and also dumped down governmental decision-making into forest companies. That's like a trajectory going off in this direction. Chilcotin Nation goes off in a fundamentally different direction. How we haven't been involved in really serious work urgently together to reform that kind of regime is, I'm astonished. I mean, the longer we delay these urgent and important shifts, and I would include mining in that, the further we set the table and the foundation for real conflict in British Columbia between Indigenous peoples and the Crown and industry. We need to be acting as mature, responsible governments to address the realities in front of us. We have to be working together to overcome the tension and the potential for rupture and breakage if it's left unattended. We have to be able to work together to take the steps that are necessary to responsibly bring about the change in an orderly way together, so that economies are not unnecessarily breaking. And so I find it to be very urgent work. It's work that should be, that the Crown, you know, and this gets back a little bit to the change in culture that's necessary inside of government, because the days of the Crown getting advice either from lawyers or from bureaucrats that, you know what, we can get through this. We can just simply operate on a reactionary crisis-based management scenario to these fundamental changes and developments in Canadian law and politics. Rather than going through the major shifts and transformations that we all know have been inevitable, and we're here now. This is the time now to grapple with them and deal with them. Instead of the advice being, look, you know what, you don't need to do that. Let's just, we'll stand pat. And if there's a First Nation that raises enough of a ruckus, maybe we'll give them some time and attention, and on a one-off basis, we'll make some adjustments. I mean, that's just not going to work anymore. And so It's not good for the provincial economy. It's not good for the federal economy. And it's not good for Indigenous people's economic reality for these economies to be unnecessarily disrupted in ways that are that are destructive. You know, that's we should be working together to try to figure out the orderly transition. And so that's Merle, in relation to I know that you talked about a whole bunch in your question and your comment there, but that's the stuff that for me comes to mind. Is that this is a time for Indigenous governments and the provincial crown and federal crown to sit at a table as responsible governments and to address together the very real and urgent matters in front of us. Because if we're not working in that kind of coordinated way, then all that's going to be happening is conflict will further deepen and develop to the detriment of all of us. Thanks.
Great. Great.
Can I jump in quickly and maybe this is a provocative point to end on, but I'll go ahead. We've spent a great deal of time in this discussion and the last discussion speaking about the Crown, and I think that's appropriate because we know that there are many, many changes that need to happen on that side of things. And we have often, in this discussion, I've noticed, collapsed Crown and industry into a singular entity, and they are most certainly not. And we need to, in many respects, consider industry as connected to Crown, particularly when we talk about natural resource extraction, but not in and of itself the same. Industry can and does work independently of Crown very often and makes negotiated agreements with Indigenous peoples, both in BC and well beyond it. And what I am showing in some of my comparative work is actually work that is in many ways agnostic to the state structure. It is particularly Indigenous self-determining in order to deal with industry. And the state apparatus may be the third party at the table in some cases. And that is a possibility that I think we need to keep our eyes open to. And so maybe part of what I'm suggesting here is that a part of the path going forward is not to deal only vis-a-vis the Crown, but also to extend the menu of examples and the menu of opportunities from a comparative lens and get that information into the hands of Indigenous communities and Indigenous leadership so that they know what the conditions of possibility are when they are approached by industry and how they can help build up their own capacity and again find ways to translate their own Indigenous legal orders and norms of governance into a space that is understandable and legible by industry. And then the Crown may actually be the third party in some cases that's brought along once those agreements and institutions are already set up. So I'm just going to end my comments on that point.
Thank you very much, Cheryl. And unfortunately, we're just about at time for this very lively conversation. I would like to turn to Dave for final comments. Before that, I just want to remind you again about the dispute resolution survey relating to impact assessment. So Dave Porter, the CEO of the BC First Nations Energy and Mining Council, has requested a survey be made available for First Nations interested in providing input on impact assessments. The First Nations Energy and Mining Council is collaborating with the Impact Assessment Agency to better understand the wishes of Indigenous communities with respect to dispute resolution in impact assessments under the new Impact Assessment Act. The goal is to identify ways to support nations when these federal processes occur. As you may know, the federal and provincial governments have passed new environmental assessment laws last year. Of interest to FNEMC is to understand what types of dispute resolution mechanisms are of interest to First Nations. A report will be developed and posted on the FNEMC website in the second quarter of 2021 for First Nations. The survey will be opened at the end of the third webinar on December 10th, and of course a draw for an Apple iPhone will be held on December 11th for those participating. The link to the survey can be found at FNEMC.ca under the Events and News tab. I do want to remind the panel, remind the participants that the papers are going to be available on the First Nations Energy and Mining website, council website, fnemc.ca in the resources section. Also, a recording of this session will be available in the next couple of days there as well. And since Dave gave me the freedom to just mention the panel that the ILI is hosting on Monday, December 7th. It is an experts panel with Ethel, Blondin, and Andrew, the Right Honorable Paul Martin, as well as Ambassador Bob Ray, who will be speaking to the importance of Indigenous-led conservation and stewardship as a genuine foundation for a better future of Canada. You can find more information on that event here in the chat, where I will paste the Eventbrite link. So please register. We'd love to see as many of you participate as possible. So at this time, I'd like to turn it over to the CEO, Dave Porter, for final closing comments before we will finish with Elder Larry Grant.
Thank you very much, Val. Hopefully you can see me and hear me. I'd like to make a brief comment before officially closing. We now have a new cabinet here in British Columbia, so one would assume that the implementation discussions will move forward with respect to the declaration legislation here in British Columbia. One of the major irritants for jurisdictions like British Columbia and the Yukon is the whole question of free entry. And what happens is that anyone with a computer and a credit card can stake in British Columbia and create a legal interest on the land. And that particular issue was litigated in the Yukon, and the courts held that particular aspect of legislation over 100 years old was ultra vires and should not have any legal effect. As a consequence, 50,000 square miles in southeast Yukon, you cannot stake any mining interests. And here in British Columbia, we have established a table with the Ministry of Energy, Mines and Resources. And we had a process that was set up. We had a table with that ministry, and we were talking about the Mineral Tenure Act. However, the minister of the day withdrew and basically pulled away from those discussions. And the excuse that was given was, we cannot continue this work at this moment because we have impending legislation to give recognition to the UN Declaration. So the talks stopped. We got the legislation, the UN Declaration, and the government did not proceed with the Mineral Tenure Act. Rather, the government unilaterally proceeded to bring two amendments forward, one to the Mines Act and one with respect to the Clean Energy Act, with no discussions on consent, no discussions on consultation. So our advice to the Leadership Council and the legal representatives that are engaged to support the Leadership Council is that we have to be assured that the government is going to commit itself to what it has legislated, and that we are not going to see any unilateral action on the part of independent ministries advancing their own legislative agenda without compliance. So I think that that is a serious issue, and that there should be an agreement on a mechanism as to the priority of legislation and the process of how you bring legislation forward in light of the UN Declaration. So that's a comment relative to this discussion. In all probability, we'll pick that discussion up in our next webinar, which is going to be held on December the 10th. And Valerie, you've done such a great job. We're inviting you back to moderate and facilitate that discussion as well. And I would like to extend a heartfelt thank you to today's panel. The discussion was riveting. And all of our panelists today were able to, I think, explain in a very understandable language some very complex issues. And so we're indebted to all of you for not only today's presentation and the discussion, but all of the work you've done for many, many years. I remember Mr. Joff working with you on the Constitution with other legal folks and Indigenous leaders, and it's good to see that people like you continue to be committed to this very important work, and thank you for making yourself available. As to the other panelists, you've made a major contribution to this effort in framing this discussion, and it will be a discussion that will go on further. The next session will be December 10th, 9 a.m. And then following that, we're going to go into the 3 additional webinars where we will then invite our leadership to join the conversation with their views and their recommendations. And so we will announce the dates as soon as we arrive at that decision. So in closing, I'd like to once again thank the panel, thank the legal representatives of the Leadership Council who have participated in this process, and as well recognize the support of the BC Law Foundation for this work, and as well would like to thank our elder cultural advisor, Mr. Larry Grant, for also being with us and guiding us through this process and wrapping us around culture and ceremony. Back to you, Val.
Thank you very much, Dave. And I'd like to leave the final word to our elder, Larry Grant.
Thank you, Val. It's been a really, really good session. It's something that to hear what's happened in Ottawa, and hopefully it changes minds in the rest of Canada. But it's really, the real important thing that I heard today was about the water, and also about Doug White's comment, we need to work together. When we look at all of the desecration of our waterways, our streams, our rivers, and what it's doing to our livelihood and our wellness within our communities, we all have to remember those waterways drain into the main rivers, but those waters are for all of us. And I remember back in the 90s when they were trying to, through the Aboriginal fishery strategies to give and declare that the fish had to have water rights, very much like what's going on in New Zealand, in the sense of recognizing river and waterways and streams for the livelihood of the fish and the fishermen, but also the lives of all of our communities that are tied into the waterways that we have lived on for millennia. And I heard a little comment with Cheryl on the legislation, something about the doctrine of discovery being disregarded in the sense that it should not be applicable. And I know that's something that needs to be worked at the UN table. For that doctrine of discovery to be declared a crime against humanity policy, and it should be completely abolished worldwide and recognized that it's abolished worldwide, so that we can move forward in a little better frame towards Indigenous self-governance and self-regulation. So I want to say thank you again to all of the panelists with the discussions that were presented today. And it sends a very hopeful message in my mind. So, Colette Gunte Tiatala, Taswalap, Kageb Shuhi, Tina Whale, Inanimate Muxtemo, Quis, Zeta Wheatles, to Holmokach Mastayu, Haitka, Siam, Shishasla Maslet, Lamnama, Haitap Kasiam, CSM. Thank you very much. Thank you.
Thank you very much, Elder Larry Grant. And with that, we wish you all a lovely afternoon, and we'll see you on December 10th.
Sure.
Should have known. Now, who sent this?
Alan.
Hmm?
Alan.